everyone. My name is Alessandro Gabriel Tiaga, and I will be presenting Title 8, Corporate Books and Records, and Title 9, Mergers and Consolidations, which covers Section 73 to Section 75 of the Revised Corporation Code of the Philippines.
Starting off with Section 73. Section 73 mandates that all corporations are required to keep and carefully preserve records at their principal office. Now, these records must include first is the Articles of Incorporation and their bylaws, including all their amendments. Second is the current ownership structure and voting rights of the corporation. Now, this includes lists of members, stockholders, group structure, intergroup relations, and beneficial ownership details. Now, third is the name and addresses of all board members and the executive officers, and a record of all business transactions. Now, continuing, a corporation must also maintain a records of resolutions made by the board and stockholders or members. Second, the copies of the latest reportorial requirements submitted to the commission. And importantly, the minutes of all meetings of stockholders, members, and the board. Now, these meetings shall include details such as time, place, authorization, agenda, and attendance. Now, any actions, protests, and motions shall be recorded upon demand. Now, these records ensures transparency and serve as the essential reflection of the corporation's operations. Now, as to inspection for corporate records, all corporate records, regardless of format, must be accessible to its directors, trustees, stockholders, or members. Now, inspection can be made in person or through a representative during reasonable business hours. Now, copies can be made in writing. However, take note that confidentiality, of course, remains crucial, as governed by laws like the Securities Regulation Code, the Data Privacy Act, and the Intellectual Property Code. Because it is important to take note that not everyone has the right to inspect and reproduce corporate records, and those individuals who are excluded from this right are those who are acting in bad faith, competitors, or non-stockholders or members, and abuse of inspection rights may result in penalties under Sections 158. And similarly, corporate officers who may refuse for valid inspection requests may be liable under Section 161. This ensures fair use of corporate records while maintaining balance between transparency and protection of sensitive information. In cases where inspections are denied, the aggrieved party can report the issue to the Commission, and within 5 days, the Commission will investigate and order the corporation to allow reproduction and inspection of the corporate records. However, such refusal can be defended when it arises from or when the requesting party has no legitimate purpose, is arising from a competitors, and lacks good faith. Lastly, stock corporations must maintain a stock and transfer book which record details such as stockholder names arranged alphabetically, payment of stock installments, transfer and sales of stocks, including dates and parties involved. Now, this book should be accessible at the corporation's principal office or its stock transfer agent, and shall be open for any inspection by any director or stockholder of the corporation at reasonable hours on business days. Now, stock transfer agents, or one engaged principally in the business of registering transfers of stocks on behalf of a stock corporation, must secure a license from the Commission to operate in the Philippines, ensuring their reliability, of course. Now, lastly, independent transfer agents may also be required for corporations trading in secondary markets. Now, let us move to the next section under Title 8, Section 74, which is Right to Financial Statements. Now, this section ensures that stockholders and members have access to the financial transparency in the corporation's operations. Section 74 provides the following rights and responsibilities regarding financial statements. First, corporations are required to furnish their stockholders or members with their most recent financial statements, in accordance, of course, with the reporting requirements set by the Commission within 10 days upon receiving written requests.
Second, during the regular meeting of stockholders or members, the board of directors or trustees must present a financial report of those corporation's operations for the preceding year. This includes the financial statements signed and certified in accordance with the revised corporation code and the commission regulations. Now, for corporations with total assets or liabilities less than 600,000 pesos or an adjusted amount as determined by the Department of Finance, these financial statements can be certified under oath by the treasurer and the president rather than undergoing full certification requirements. Next, let's proceed to Title 9, Merger and Consolidation under the Revised Corporation Code of the Philippines. Now, this segment covers Section 75, which is Plan of Merger or Consolidation, which details the procedure of merging or consolidating corporations. Now, Section 75 outlines the process by which two or more corporations may either first merge into a single corporation which becomes the surviving entity. Now, a merger is a union whereby one or more existing corporations are absorbed by another corporation that survives and continues the combined business. And here, one corporation survives, right? While the rest are dissolved and all their rights, properties, and liabilities are acquired by the surviving corporation. Now, even though there is a dissolution of the absorbed corporation, there is no winding up of their affairs. Second is the consolidate into a new single corporation. It's a consolidation. It is the union of two or more existing entities to form a newly entity referred to as the consolidated corporation. It is important to take note that this do not become effective upon mere agreement of the constituent corporation. Since a merger or consolidation involves fundamental changes in the corporation, there must be an express provision authorizing them. Now, the process begins with the board of directors or trustees of each participating corporation approving a comprehensive plan of merger or consolidation. This plan must include first the name of the corporations involved, referred to as the constituent corporations. Second is the terms and modes of implementing the merger or consolidation. Third is any changes of the articles of incorporation of the surviving corporation, in case of merger, of course, and a complete statement of the required provisions of the new corporation in case of a consolidation. Now, any additional provisions deemed necessary to desirable for the merger or consolidation, this process ensures that all the aspects of merger or consolidation are well documented and legally compliant. And that is all.
Let's move on to Title 9, Merger and Consolidation, Section 76, Stockholders of Members Approval. This section of the Corporation Code of the Philippines outlines the process for obtaining stockholders or members' approval for mergers and consolidations. The Board of Directors or Trustees of each corporation involved in the merger or consolidation must first approve a plan that details the terms of the merger, changes to the articles of the incorporation, and other relevant information. The approved plan is then submitted to the stockholders or members of each corporation for their vote at separate meetings. A 2/3 majority votes of the outstanding capital stock is required for stock corporation, while a 2/3 majority vote of the members is necessary for non-stock corporation. Dissenting stockholders in stock corporation have the right to demand an appraisal of their shares. However, this right is extinguished if the board directors abandons the merger plan after stockholder approval. Amendments to the plan can be made, but they are require approval by a majority vote of the respective boards of directors and ratification by a 2/3 majority vote of the stockholders of members of each corporation. In conclusion, Section 76 ensures that mergers and consolidations are not undertaken without the consent of the majority and stockholders members. This process safeguards the interests of all stockholders and promotes transparency and corporate restructuring. That's all for Section 76. Next, the Revised Corporation Code of the Philippines, Republic Act No. 11232, outlined the process for corporate mergers and consolidation in Title 9, Section 77 specifically addresses the articles of merger or consolidation, which are the formal documents that outline the key aspects of the merger or consolidation agreement. This section mandates that after obtaining stockholder or member approval, as outlined in Section 76, the constituent corporation must execute articles of merger or articles of consolidation. These documents serve as formal agreements outlining the merger or consolidation plan and are signed by the president or vice president and certified by the secretary or assistant secretary of each corporation. Section 17 plays a crucial role in the merger and consolidation process by formalizing the agreement. So the articles of merger or consolidation serve as legally binding document that outlines the terms and conditions of the transaction. Next, ensuring transparency. The required disclosure in the articles provides stakeholders with essential information about the merger or consolidation, including financial details and voting result. Next is facilitating the Security and Exchange Commission approval. The SEC reviews the articles to ensure compliance with the revised corporation code and other relevant laws. Next, protecting creditor rights. The articles acknowledge the rights of creditors and ensure that their interests are not impaired by the merger or consolidation. So, in conclusion, Section 77 of the revised Corporation Code is a critical component of the merger and consolidation process, ensuring that these transactions are conducted in a transparent and legally compliant manner. The articles of merger or consolidation serves as a formal agreement, the key aspect of transaction, protecting the rights of all stakeholders, and facilitating the successful completion of the merger or consolidation. That's all for the Section 77. Let's move on to Section 78. Effectivity of the merger or consolidation. Section 78 of the Revised Corporation Code of the Philippines, Republic Act Number 11232, outlines the process for making the merger or consolidation legally effective. This section details the steps involved in obtaining approval from the Securities and Exchange Commission and the specific requirements for certain types of corporation. So these are the highlights of Section 78. First is the submission to Security and Exchange Commissions. The articles signed and certified as required by the Code must be submitted to the SEC for approval. For mergers or consolidations involving banks, banking institutions, loan associations, trust companies, insurance companies, public utilities, educational institutions, and other special corporations governed by special laws, a favorable recommendation from the appropriate government agency must be obtained first. Next step is Securities and Exchange Commission's approval. The SEC will review the articles and plan of merger or consolidations to ensure they are consistent with the provisions of the Revised Corporation Code and existing law. If the SEC is satisfied, it will issue a certificate approving the articles and plan of merger or consolidations. This marks the moment when the merger or consolidations becomes effective. Next process is the hearing process. If the SEC, upon investigation, believes the proposed merger or consolidation is contrary to or inconsistent with the provisions of the Code or existing laws, it will set a hearing to give the corporation involved the opportunity to be heard. Written notice of the date, time, and place of the hearing must be given to each constituent corporation at least 2 weeks before the hearing. The SEC will then proceed as provided in the Code. In conclusion, Section 78 of the Revised Corporation Code establishes a clear and structured process for ensuring that mergers and consolidations are legally effective. The SEC's review and approval process safeguards the interests of stakeholders and ensures compliance with the law. This section highlights the importance of transparency, accountability, and due process in corporate restructure. That's all for Section 78.
Good day everyone, I am Jubil Daviles and I will be presenting Title 9, Merger and Consolidation, and Title 10, Appraisal Right, specifically Section 79 to Section 81. Good day everyone, in this presentation we will now delve into significant provisions of the Revised Corporation Code, specifically Section 79, which discusses the effects of merger or consolidation. These legal effects outline how corporations are impacted when they combine their operations to become a single entity, either through merging into one of the existing corporations or forming an entirely new one. Understanding these effects is crucial for both practitioners and stakeholders to ensure proper compliance and planning during such corporate restructuring. To begin with, subsection A explains what happens to the constituent corporation involved in a merger or consolidation. In a merger, a constituent corporation are combined into a single entity, referred to as surviving corporation, which continues to exist. In contrast, in a consolidation, a new corporate entity is formed, known as the consolidated corporation, which replaces all the constituent corporations. This process is formalized and detailed in a respective plan of merger or consolidation, ensuring a clear designation of the new corporate structure. Next, subsection B highlights the cessation of the separate existence of all constituent corporations except for the surviving or consolidated corporations. Essentially, this means that all merging entities aside from the surviving or newly formed corporation, lost their individual legal identities. This provision simplifies the legal structure and ensures that there is only one entity carrying forward the business and obligation. Subsection C further clarifies the position of the surviving or consolidated corporation. It states that this corporation inherits all the rights, privileges, immunities, and powers of a corporation under the Revised Corporation Code. Additionally, it assumes all the duties and responsibilities. This ensures continuity in operations while adhering to the legal framework that governs corporations in the Philippines. Subsection D addresses the transfer of assets and interest. Upon the merger or consolidation, all forms of property, whether real or personal, along with receivables, subscription, and other rights are automatically transferred to the surviving or consolidated corporation. This transfer occurs without the need for additional legal actions, making the process more efficient. It ensures that the surviving or new corporation can seamlessly take ownership and control of all assets previously held by the constituent corporation. Finally, subsection E emphasizes the liabilities and obligations of the surviving or consolidated corporations. It specifies that this new entity will be responsible for all the debts and legal obligations of the constituent corporations, as if it had incurred them directly. Furthermore, any ongoing legal claims or actions involving the merging corporations can proceed against the new entity. Importantly, this provisions protects the rights of the creditors, ensuring that their claims and liens on the property remain valid even after the merger or consolidation. Moving forward, we discuss Title 10, specifically Section 80, which introduces the appraisal right. This provision safeguards the interest of stockholders by allowing them to dissent from certain corporate actions and demand the fair value of their shares. This appraisal right is particularly relevant in situations where significant corporate decisions might negatively affect the stockholders' interest. Let us explore the instances where the right can be exercised. The first instance is when amendments to articles of incorporation affect stockholder rights. Example of these includes the changes that restrict the rights of a particular class of shares, authorize new preferences superior to existing shares, or alter the corporation's terms of existence by extending or shortening it. Such changes could significantly impact stockholders' ownership and influence within the corporation, which is why the appraisal right is made available. Another situation arises when a corporation decides to dispose all or substantially all of its assets. This includes the actions like selling, leasing, transferring, or mortgaging the company's property. Such decisions can alter the corporation's business model or even its viability, which could lead stockholders to dissent and exercise their appraisal rights to protect their investments. The right of appraisal also applies during mergers or consolidations, as these corporate actions fundamentally change the structure and operations of the company. Stockholders who disagree with the merger or consolidation plan can demand payment for the fair value of their shares rather than remaining part of the newly restructured entity. Lastly, stockholders may exercise their appraisal rights when corporate funds are invested for purposes outside the primary purpose stated in the Articles of Incorporation. Such actions could divert the corporation's focus and resources into areas that stockholders might not have originally supported, thus giving them the right to dissent. Now, let's discuss how this right is exercised. As outlined in Section 81, a stockholder who dissents must vote against the proposed corporate actions and within 30 days make a written demand for the payment of their fair value of their shares. If this demand is not submitted within the specified period, the stockholder is considered to have waived their appraisal rights. This step ensures clarity and finality in the decision-making process. If the stockholder and corporation cannot agree on a fair price within 60 days, the shares are now appraised by three disinterested persons, one by the stockholder, one by the corporations, and a third by mutual agreement. This majority decisions is binding and payment must follow within 30 days. However, this is subject to the corporation's unrestricted retained earnings.
Good day everyone, I'm Eliza Gasso and I will be discussing Title 10 Appraisal Right under Section 82 to Section 84. So let's start with Section 82. Section 82, Effect of Demand and Termination of Right. From the time of demand for payment of the fair value of a stockholder's shares until either the abandonment of the corporate action involved or the purchase of the said shares by the corporation, all rights accruing to such shares, including voting and dividend rights, shall be suspended, in accordance with the provision of this code, except the right of such stockholder to receive payment of the fair value thereof, provided that if the dissenting stockholder is not paid the value of the said share within 30 days after the award, the voting and dividend rights shall immediately be restored. So here, it's simple to understand. However, Section 82 is too long, so I will highlight the important term that you should remember. First, all rights accruing to such share, including voting and dividends right, shall be suspended. So when a shareholder rights are suspended, they temporarily lose their ability to vote on the corporate matters and receive dividends from their shares. This can occur for various reasons, such as during a dispute over share ownership or valuation. Second, the dissenting stockholder shall be entitled to receive payment of the fair value of his share. A shareholder is entitled to receive payment equivalent to the fair value of their shares. This value can be agreed upon by the shareholder and the corporation, or determined by appraisers if an agreement cannot be reached. And lastly, if a shareholder is not paid the agreed or appraised value of their share within 30 days, their rights to vote and receive dividends are restated. Until they receive payment, this provides a measure of protection for shareholder awaiting compensation. That's all for Section 82. Next is Section 83. Section 83. When right to payment ceases, no demand for payment under this title may be withdrawn, unless the corporation consent thereto. If, however, such demand for payment is withdrawn with the consent of the corporation, or if the proposed corporate action is abandoned or rescinded by the corporation or disapproved by the commission, or such approval is necessary, or if the commission determines that such stockholder is not entitled to the appraisal right, then the right of the stockholder to be paid the fair value of the shares shall cease. The status as the stockholder shall be restored, and all dividend distribution which would have occurred on the shares shall be paid to the stockholder. Section 83 addresses the circumstances under which the stockholder's right to payment for appraised share may be terminated. Firstly, the corporation consent to the withdrawal. A stockholder who initially demand payment for their shares as part of exercising their appraisal right can decide to withdraw this demand. However, for the withdrawal to be effective, the corporation must consent to it. This means both parties agree to revert to the status quo before the demand was made. Secondly, the proposed corporate action is disapproved by the SEC, where its approval is necessary. Certain corporate action require approval from regulatory bodies like SEC. If the SEC disapproves the action, it cannot proceed, and thus the appraisal right associated with it become irrelevant. Thirdly, the proposed corporate action is abandoned or rescinded by the corporation. So if a corporation decided not to proceed with the proposed action, such as merger or an acquisition, the basis for the appraisal rights no longer exists. In such cases, the action is considered abandoned or rescinded, and the appraisal rights are effectively nullified. And lastly, the SEC determines that such stockholder is not entitled to the appraisal right, because the SEC has the authority to evaluate whether a stockholder is entitled to appraisal right based on specific legal criteria. If the SEC determines that a shareholder does not meet these criteria, the shareholder cannot pursue appraisal rights. In general rule, a dissenting stockholder who demands payment of his share is no longer allowed to withdraw from his decision. That's all for Section 83. Let's proceed to Section 84. Section 84. Who bears cost of appraisal? The costs and expenses of appraisal shall be borne by the corporation, unless the fair value ascertained by the appraisers is approximately the same as the price which the corporation may have offered to pay the stockholder, in which case they shall be borne by the latter. In case of an action to recover such fair value, all costs and expenses shall be assessed against the corporation, unless the refusal of the stockholder to receive payment was unjustified. The important key terms here is the fair value ascertained by the appraiser is approximately the same as the price which the corporation may have offered to pay the stockholder, in which case they shall be borne by the stockholder. It means that the fair value in corporate transaction estimate a stock worth based on financial performance and market conditions, providing a benchmark for a stockholder considering selling. When a appraiser's fair value aligns with a corporation buyback offer, it indicates the offer is a fair market reflection. Typically, appraisal costs fall on the stockholder when the fair value matches the corporation's reasonable offer. In general rule, the corporation shall bear the cost of appraisal. That's all for my part. The next proceeding section will be discussed by the next reporter. Thank you.
Good day, I am Labia Andobrio and I'll discuss the Revised Corporation Code Title 10, Section 85 and Title 11, Section 86 and 87. Here are the highlights of this section. First, notation of liens or restrictions. Any lien or restriction on the share of stocks must be explicitly stated in the certificate of stocks. If no such notation exists, the corporations cannot enforce the lien or restrictions against third parties. Second, right of transferees. A transferee who acquires shares without knowledge of any restrictions due to lack of notations is not bound by such restrictions. This ensures protection for transferees acting in good faith. Third,
Good faith protection. A transferee who acquires stock with no indication of a lien or restriction on the face of the certificate is presumed to be acting in good faith and has full rights to the shares. And lastly, corporation's responsibility. It is the corporation's duty to ensure all liens or restrictions are clearly reflected to the stock certificates. So now, let's proceed to the Revised Corporation Code, Title 11, Section 86, Definition of Non-Stock Corporations. First, what is the definition of non-stock corporation? Definition of non-stock corporation. A non-stock corporation is a corporation organized primarily for purposes other than profit, such as charitable, educational, cultural, religious, or social purposes. Second, use of income. All income and profits are utilized for the furtherance of the corporation's purpose. Third, membership. Non-stock corporations have members instead of stockholders. Membership rights and privileges are determined by the articles of incorporations or bylaws. Fourth, no share of stocks. Non-stock corporations do not issue share of stocks. And lastly, purpose. The focus is on service, advocacy, or other objectives rather than generating profit. These sections of the Revised Corporation Code of the Philippines distinguish non-stock corporation from for-profit corporations, emphasizing their mission-driven and non-distributive nature.
Good day, everyone. My name is Daisy Sara. I'll be discussing the Title 11 Non-Stock Corporation. Chapter 1, the topic is Member, under Section 88 to 90. First, let me discuss the Section 88. Section 88 of the Revised Corporation Code of the Philippines, the voting rights of members. Section 88 outlines voting rights of the members in corporation, providing flexibility while ensuring fairness in corporate governance. It allows the voting rights to be limited, prudent, or denied specified in articles of incorporation or bylaws. In the absence of such provisions, the default rule applies, granting each member has only one vote. Members may also delegate their voting rights through proxies unless restricted by corporations' governing documents. This is to ensure the participation even in their absence. Furthermore, the bylaws may permit voting through remote communication or in absentia, making this process is more to making this process to be more inclusive or accessible, particularly in geographically distant members or yung malalayo. This modern approach aligns with the technological advancement, enhancing participation while maintaining flexibility in corporate governance. Now let's proceed in Section 89, the Revised Corporation Code of the Philippines, the non-transferability of membership. Section 89 underscores personal nature of membership in non-stock corporation, establishing the membership along with its accompanying rights is generally personal and non-transferable. This reflects the principle of membership in such organization is often tied to personal qualification and relationships and contributions. For instance, professional associations or civic organization rather um, may be granted membership based on their individual expertise, achievements, or alignments with the company's objectives. However, these rules is not absolute. If the articles of incorporation or bylaws is explicitly permit the transfer of membership, then such transfer is allowed. This flexibility ensures that corporations can tailor the membership rules to align with their operational needs and goals, while still preserving the unique governance characteristic of non-stock corporation. Now, let's move on and proceed to my last part of this presentation or reporting. The Section 90 of the Revised Corporation Code of the Philippines, the termination of membership. Section 90 governs the termination of membership in non-stock corporation, outlining the conditions and consequences of such termination. Membership can be terminated in a manner and for the causes specified in the Articles of Incorporation or bylaws, which allows corporations to define the grounds or procedures for ending a member's affiliation. Upon termination, all rights of the members in the corporation or its property are extinguished, unless otherwise stated in the corporation's governing documents. This provision emphasizes the finality of termination while allowing the flexibility of exemption where articles of incorporation or bylaws provide retention of the certain rights.
Hi everyone, my name is Ashley May Zapanta and I am here to tackle about Title 11, which is the Non-Stock Corporation, Chapter 2, Trustees and Officers, and Chapter 3, Distribution of Assets of Non-Stock Corporation. Let me explain Section 91 in simple terms. It's all about how trustees are chosen or elected, how long they serve, and some basic rules about their role. First, corporation must decide how many trustees they will have, but the number can't go above 15. This number is written in the corporation's Articles of Incorporation or bylaws. Trustees can serve for a maximum term of 3 years. They remain in office until their successors are elected and officially take over. This ensures there's always someone in the role. If a trustee leaves or there's a vacancy before the end of the term, a new trustee can be elected. This new trustee will only serve for the unexpired period of the original term. So, if 2 years of the term are left, the new trustee will serve for 2 years and not 3. For most corporations, only members of the corporation can be elected as trustees. However, there's an exception. For independent trustees in non-stock corporations that are involved in public interest, they don't necessarily have to be members of the corporation. Unless the Articles of Incorporation or the bylaws say otherwise, members of a non-stock corporation can directly elect their officers. This gives members more direct control over leadership. So, let's go to Section 92. This section explains how a corporation should manage its list of members and proxies and where meetings can be held. First, the corporation must always keep an updated list of its members and the people they've chosen to act as proxies. This list should be in the format required by the Securities and Exchange Commission. This list needs to be updated at least 20 days before any scheduled election. This is to make sure all members are properly recorded before voting. Now, about meetings, the corporation's rules called bylaws can say that meetings can be held anywhere, even outside the corporation's main office. However, all members must be notified about the meeting's date, time, and place. One important rule is that the meeting must take place within the Philippines, so the meeting can't be held outside the country. In short, the corporation must keep an updated list of members and proxies, update it 20 days before elections, and hold meetings within the Philippines with proper notice to all members. So now, let's talk about Section 93, Rules of Distribution. This section explains how a non-stock corporation assets should be distributed when it dissolves, except in cases covered by Section 139. So the steps are: A. The corporation needs to pay off any debts or make sure there's a plan to pay them off. And letter B, if the corporation holds assets that must be returned or transferred when it dissolves, it has to follow those rules and return or transfer them as required. So now, moving on to the next steps, letter C, if the corporation has assets meant for charitable, religious, or similar purposes and they don't need to be returned, they should be given to another organization with a similar purpose. This will be decided in a distribution plan. Letter D, for any other assets, they will be distributed based on the corporation's articles of incorporation or bylaws. These documents may specify how assets should be shared among members. And letter E, if none of these apply, the remaining assets can be given to individuals or organizations as decided in the distribution plan.